Professor Erika Lietzan is an associate professor of law at the University of Missouri School of Law. Professor Lietzan researches, writes, and teaches primarily in the areas of drug and device regulations, intellectual property, and administrative law. She recently completed a historical and empirical examination of the new drug research and development paradigm in the United States and the relationship between the length of that process and incentives to innovate. Prior to teaching, she was in private practice, including 8 years as a partner at Covington and Burling in Washington, D.C. Professor Lietzan was involved in every major amendment to the Federal Food, Drug, and Cosmetic Act between 1997 and 2014, working as outside counsel and sometimes lobbyist for various individual companies as well as the trade association PhRMA. She serves in the leadership of the Food and Drug Law Institute and served for many years in the leadership of the Science and Technology section of the American Bar Association. The professor received a bachelor's degree in history from the University of North Carolina, where she graduated with honors, her master's degree in history from UCLA, and a law degree with high honors from Duke Law School. Professor, welcome.
Chairman Marino, Ranking Member Cicilline, and members of the subcommittee, thank you for this opportunity to speak with you today. I was asked to talk about 3 aspects of the FDA framework that are the focus of complaints that brand companies are acting improperly and may be violating antitrust law. The first is FDA's citizen petition process, which furthers the open government principles of transparency, public access, and accountability. Anyone may petition FDA to take any administrative action, and the petition and any comments on it are public documents. Petitions play an important role in our political system. The public has a strong interest in ensuring that executive branch agencies work within the constraints of the laws that Congress writes. And a robust petitioning practice adds a layer of surveillance to complement the oversight function of the legislative branch and the review function of the judicial branch. You have been told that brand companies file frivolous petitions that delay generic drug approval. These claims rest on anecdote and rhetoric, not evidence. Congress passed a law in 2007 stating that FDA may not delay approval of a generic drug due to a petition unless necessary to protect the public health. Since then, FDA reports only 5 generic drugs have been delayed without public health justification out of more than 4,000 copies approved. A high denial rate is not proof that petitions are frivolous. Drug approval decisions can require difficult judgment calls about appropriate regulatory policy in the face of scientific uncertainty and about the flexibility of the law to accommodate new facts. Differences in opinion and perspective are natural. A valid petition may simply lack persuasiveness at the end of the day. Congress has also been told that innovative companies use REMS restrictions to block generic drug approval. To the best of my knowledge, though, innovators refuse to provide samples primarily because they have concerns that requesting companies lack adequate safeguards to address the risks presented by these drugs. And these concerns are reasonable. Access restrictions are usually imposed to mitigate severe side effects, like birth defects or irreversible organ damage. And even minor lapses in safety protocols by any party at any point can have horrific consequences. If Congress wants to encourage innovators to provide samples, it should protect them from liability arising out of the actions of a third party once a restricted drug has left the innovator's special access system. We should not force innovators to provide their products to generic companies. If a drug is under patent, this would require the company to practice its patent for the benefit of a competitor. It is a bedrock principle of U.S. law that a patent owner has no duty to practice its patent at all. We lack evidence of a systemic problem that would justify such a fundamental change to the intellectual property system. Only 22 brand drugs have access restrictions and no generic applications, and more than half of those are so new that FDA statute doesn't allow approval of a generic or biosimilar anyway. It's not clear how many, if any, lack generic competition because an innovator didn't share its drug. Finally, there are concerns when the price jumps on a drug that has been inexpensive for years. Sometimes this results from FDA's unapproved drugs initiative, and it's important to understand why this happens. Several thousand drug products are marketed without the required FDA approval. Many have been used for half a century or longer, and some are even covered by insurance. Some are not safe. Others are not effective, which is a problem because it keeps patients from drugs that do work. FDA focuses its enforcement efforts on the companies that sell these drugs, which present a public health concern. FDA can't force the other companies to file applications. It would have to threaten enforcement action, and enforcement action threats are effective only if backed up. This would require resources that FDA doesn't have. It would also take medicines away from patients. So after approving an application, FDA removes the competing products from the market. This ensures that patients receive the specific product that was studied, and it preserves the integrity of the approval system. It also encourages applications. Usually generics can be approved 3 years later, but in the meantime, the company that submitted the application can recover its costs. This company hasn't done anything wrong. In fact, it's the one company that chose to comply with the law, to bring an illegally marketed product into the FDA system, but the system has taken away a cheap medicine from patients. Clearly, we need a better solution that maintains the integrity of the drug approval scheme, but doesn't deprive patients of drugs they rely on. In sum, regulated industries, consumers, and other stakeholders share responsibility with FDA for the public health mission enshrined in the statute. When rhetoric and anecdote are laid aside, the evidence suggests that regulated entities generally operate in good faith within this framework, and when companies protect their property rights, participate in open government, or protect themselves from unfair liability exposure, it would be a mistake to take action against them. Instead, we should look for ways to support FDA in its public health mission and to encourage private choices that we prefer as a public policy matter. Thank you.
Thank you, Professor. I'm going to start off with a question that for each of you, if you care to answer it. I'll start with Professor Olson and work our way down to Dr. Kesselheim, and then I have another question that I would like each of you to respond to if you care to, and then I would start with Dr. Kesselheim, okay? Concerns have been raised that the approval of a generic alternative REMS distribution system will inevitably lead to patent infringement systems. Given the likely overlap with the branded manufacturer's original distribution system, do you anticipate this being a problem? And I have been a critic of wanting to so much bring the Patent and Copyright Office into the 21st century. So, Professor Olson.
Yes, Mr. Chairman. I do think that the way that patents are written, the fact that they have to track the statute very closely means that it will be very easy to bring infringement suits. Even if the patent is found invalid or the suit is not successful, this listing them in the Orange Book and the litigation can significantly delay generic entrants. Furthermore, there's no additional incentive that is given by granting REMS patents that is needed because there is already an incentive to create the REMS and ATASU systems because you don't get to market your drug unless you create it. They're a tiny fraction of the cost of drug development. And so by forcing sharing or at least stopping companies from arguing that if generics don't share, they may not market the drug, we're not going to be losing anything. We're not going to lose any benefit.
Professor?
Well, first of all, I disagree with Professor Olson that there isn't much difference between the statutory language and the REMS patents. The statute describes in very general terms the type of access restrictions that are permitted. And anyone who's ever worked on designing a risk management plan or negotiating a REMS with FDA can tell you that there are many ways to mitigate a risk, and the REMS themselves are very detailed, and there are a lot of decision points along the way. I think the question that matters is whether it's possible to mitigate a particular risk more than one way, and that's a clinical question and a regulatory question. It has to be answered case by case, but having worked on REMS issues for companies, my instinct is yes, there's absolutely more than one way to design a system.
Thank you. Attorney Abbott, do you care to comment?
Well, it's certainly possible, Mr. Chairman, as mentioned, there's possibility of designing around the patent. That may be tricky. There's certainly possibility of infringement lawsuits. It could also perhaps be dealt with legislatively. I mean, Congress wanted to, could make it clear that any actions taken to develop sort of a REMS system by potential entrant that is not going to be constitute patent infringement. I'm just not saying that's a good idea or not, but there may be ways to have very, very narrow modifications to try and forestall the problem of opportunistic patent litigation here. You'd have to be very careful, and maintain appropriate incentives to innovate, but as I think as Professor Olson mentioned, it probably already are given the need to meet FDA regulatory requirements to develop these systems. But I am not an expert in this area, but that's just my initial reaction.
Doctor?
I mean, I think that here we should be thinking about what's best for the patient. And to me, the best thing for a patient is to have a single REMS system because, again, these are otherwise interchangeable drugs. It doesn't make any sense if you're a clinician or a patient to be enrolling people in different REMS for otherwise interchangeable drugs based on a manufacturer that you may not know. And so I think that ultimately we should be trying to develop a system where shared REMS are able to be done and are able to be established in an efficient way. And I think that we can do that by for example, creating royalty-free licenses for patented REMS so that generic manufacturers can use them, or other mechanisms to try to encourage the development of shared REMS for patients' benefits.
I'm going to play a little devil's advocate with myself here and like to hear what you folks have to say about it, and we'll start with you, Dr. Kesselheim. I am very familiar with, because I have a very dear friend who is now retired in his 90s, who was a researcher, PhD, and working with drug companies, which I won't mention. And I saw, and he's explained to me over the years, the time, the labor, the expense that goes into developing a drug. How do we, or should we even think about that concept of the profit or not meeting the profit to make sure that companies still are in the research aspect of creating life-saving drugs? Do you understand my question? Please.
Sure. So, I mean, obviously, I think it's very important for there to be a period of time when companies can make back the investment that they had in their product and make a profit on that. But at some point, that period has to end. And currently, manufacturers, on average, get about 12 to 16 years of market exclusivity. How much more market exclusivity is necessary? I mean, pharmaceutical manufacturers currently make about 22% profit margins as compared to 7% profit margins for the rest of the Fortune 500. And so, I mean, I think that it is important both for there to be a fair return on investment, but then at some point for that to end and for a competitive market to be in so that patients can get the benefit of lower cost generic products. And I don't think what we're talking about here has any necessarily bearing on the questions of innovation. We're talking about getting timely access to generic products after an extended period of market exclusivity that already exists.
Thank you. Attorney Abbott?
I think, yes, one may agree or disagree about the appropriate length of exclusivity, but I think once the exclusivity period is over, whatever decision you make, you want to get the competitive products to the market as quickly as possible. I'll just note very briefly, one, it's beyond the scope of this hearing, but it's very important. One issue that American pharma firms face that's very serious is a single purchaser. Many foreign countries are sort of monopsony purchasers of American pharmaceuticals. They say, if you want to enter our market, we're going to dictate these price terms. So, and unfortunately, the American consumer has sort of been a loser because of that. There's been a cross-subsidization. American consumers and the American economy has paid more for drugs than foreign countries, but often that's an artifact of the foreign systems. And I don't know if you can talk about international agreements or something to deal with it, but it's part of the bigger picture, again, that's beyond the scope of this hearing.
Thank you. Professor Lietzan?
Yes, thank you. This is actually an area in which I've done a fair amount of research recently. You're right about the cost. In addition, there is a high degree of risk. There are a lot of products that are compounds that look promising at the beginning and fail through the long process. So it's expensive and risky. And a company that does this research has to recover not only the cost of researching the drug that actually got approved, but the cost of starting the process with the drugs that failed. So I have serious concerns about the adequacy of our incentives right now, and I'm particularly concerned about the products that take a really long time. Products, for example, that might prevent Alzheimer's, things for which we may need to do trials that exceed 10 or 15 years. Dr. Kesselheim is right about the average market exclusivity data, but I think recent economic data suggests that the break-even point for new molecular entities is somewhere in that 12 to 16-year range. And innovators in other industries benefit from 17 to 20 years of patent life. And if you compare that with 12 to 14 for the drugs that we desperately need, it leaves me concerned. Thank you.
Thank you. Professor Olson.
I echo the comments of Dr. Kesselheim. And just to add one thing to that, Professor Lietzan's right, of course, that the risk is very high, but the profit margin overall tells you that you're getting high risk and a pretty high reward. That takes into account all the failures. The other thing I would just add is that in my proud city of Boston, we have many biotech companies. Some of them are taking 20 or 30 years to get a pathway to a drug, and yet we have this amazing ecosystem that supports that. The system has worked without needing extension. When we grant extensions of exclusivity, or if we can end the granting of some of these extensions of exclusivity, the drug companies will also stop focusing on trying to extend and move back to a focus on R&D, and that's where we want them to focus once their drug has been patented.
Thank you. The chair now recognizes Congressman Johnson.
Thank you, Mr. Chairman. Professor Lietzan, in your written testimony, you state that requiring branded drug companies to provide drug samples to generic drug competitors is a duty to deal that will undermine innovation. How would requiring samples to off-patent drugs or drugs nearing the ending of their patent exclusivity harm innovation?
So I do believe that requiring the sale of a product ultimately requires, if it's a patented product, it requires the company to manufacture enough of the product to satisfy all of the generic applicants, all the biosimilar applicants that want it, that if the product is under patent, that requires the company to practice its patent for the benefit of one of its competitors. That is contrary to bedrock principles of U.S. patent law right now, and in and of itself will devalue the patent, which to me is concerning because decades of research show that robust patent protection is essential for pharmaceutical innovation.
All right, and Mr. Abbott, do you agree with Professor Lietzan's characterization that providing drug samples is a duty to deal? Do you agree with that?
Well, Congressman, I think one has to look at this duty as a general matter in an unregulated context. There isn't normally a duty to deal. Here, the problem is that in order to enter the market, you need to get hold of these samples. So yes, you are in some sense constraining potentially intellectual property right, but it may be near the end of the patent life, and it is sort of necessary to be able to enter. And if it's necessary to be able to enter, that's one of the trade-offs. I think that that would be my response.
Mm-hmm. Dr. Kesselheim, as a practicing doctor, are you concerned that requiring access to branded drug samples would undermine patient safety?
No, I'm not. I mean, I feel like the statute is well constructed to try to prevent any risk of patient safety. But again, these samples are not being collected to then be distributed to patients. They're being collected to be put into laboratory and other clinical testing that is necessary to demonstrate to the FDA that the drug is bioequivalent and therefore the generic drug can be approved. I don't really see the risk that, for example, a drug that is used in elderly patients with a type of cancer called multiple myeloma, but also unfortunately has a birth defect risk because it's being transmitted to a generic for the purpose of conducting clinical testing so that the generic can get on the market would somehow end up in the hands of patients for whom it would cause a risk. I don't see that as a reasonable safety risk, and I do think that to the extent that there are weird ways that we could think of that might exist, the statute does a good job of trying to prevent that from happening by forcing the company to develop a plan and register that with the FDA.
Professor Lietzan, I feel compelled to offer you the opportunity to respond.
Yes, so these drugs they present very serious risks to patients, and some of them are toxic, and many times the generic companies that request samples have no experience with drugs of this sort. Some are sophisticated, but some do not. And I think the concern has always been that if anybody in the process of conducting, especially when you get to the clinical trials, if there's any sort of lapse by anybody, the clinical research organization, not the generic company, the group that they contracted with to do the bioequivalent study, if there's any sort of lapse, the consequences can be horrific. And my own view is that the concerns that the companies have are valid, and I know that many of the companies that have been the focus of attention because they have demanded assurances about safety protocols have in fact sold their products to generic companies that had adequate safety protocols, and to me that is very strong evidence of good faith.
Mr. Abbott, would you care to respond?
Well, I don't know if you were asking about the questions of safety and risk. I mean, there are perhaps Dr. Kesselheim might be best. I do know that most generic companies, they have to meet very rigorous generic companies. Some of the largest pharmaceutical companies in the United States, they have to meet in general very rigorous safety controls. They are subject to potential liability of various sorts. So, but perhaps Dr. Kesselheim might want to have some additional comments.
Doctor?
Sure. I mean, I think I said what I said before, but I think you also have to take into account the risk of not allowing this kind of normal business practice to happen, which is that very expensive drugs do not get timely generic competition, which keeps the price high, reduces access to important drugs for patients who are unable to afford access. And I think you also have to take into account that whole risk of not having a system in which businesses can exchange the product that they need in order to do the very basic FDA testing as well.
Thank you, and I yield back.
Chair now recognizes the ranking member, Congressman Cicilline.
Thank you, Mr. Chairman. I'd like to begin, if I may, with you, Professor Lietzan. I wonder if you're familiar with the Harvard Journal on Legislation written by Robin Feldman that spoke specifically about this pay-for-delay problem. And in her writing, she gives an example of In re Flonase antitrust litigation. At its peak, Flonase, a steroid nasal spray for allergy treatment, received $1.3 billion a year in sales. Through a complicated series of citizen petitions, GlaxoSmithKline was able to stave off generic entry for 23 months. Thus, the delay achieved through citizen petitions was worth approximately $2.5 billion, assuming it maintained the peak $1.3 billion in sales per year. They ended up settling that case for $185 million, so even with that large settlement, the delay may have been worth $2.3 billion. That's just a single example. So I just wonder how you square that with the suggestion in your testimony that that this doesn't continue to be a problem and that citizen petitions aren't used by brand companies for the specific purpose of delaying entry into the market and causing them to realize significant financial gains.
Sure, I appreciate the question. I'm not familiar with that particular article that Professor Feldman wrote, and I haven't looked at that particular example, and I don't know the date on it, if it might be prior to the change in the law that Congress enacted in 2007.
I think it was written last year, June
No,
2006.
I'm sorry, the actual Flonase example, because I do know that FDA itself has told Congress that there have only been 5 generic drug approvals delayed that didn't have a public health justification since that law was enacted. So it's possible, I'm not familiar with that particular example. It's possible that predates the current situation.
Thank you very much. Dr. Kesselheim, am I pronouncing that correctly?
Yes.
Thank you again for your testimony. I'm wondering whether you could speak a little bit about whether or not the Supreme Court's decision in FTC versus activists has affected the use for pay for delay settlements. Do you assess that this continues to be a problem? Even if it's not a lot of instances, these instances can impose significant costs on the consumer and significantly enrich the brand companies.
Sure. I mean, I do think that the FTC versus Actavis case has caused some shifts in, the FTC versus Actavis case was really about the FTC being able to review pay for delay settlements that included extremely large monetary transfers like handing over of suitcases full of cash. But since then, pay for delay settlements have continued. Many of them also still involve monetary settlements, but in many of them also now involve more complex co-marketing arrangements or other kinds of business deals, some of which may not necessarily be at the sort of fair value that they might have otherwise been. And these kinds of agreements persist. And I think the problem is that allowing FTC to review them is great, but it takes a really long time and a lot of resources to get through this. The Actavis case itself, which was the subject of the Supreme Court case, was started back in 2006, and we still haven't had really a full trial of it. And so I do think that congressional action is needed to try to prevent settlements that go beyond mere exchanges of litigation costs.
And do you think we ought to consider as well enactment of a prohibition, a statutory prohibition of pay for delay, like to completely prohibit that activity as a matter of law?
Well, I mean, I do think that the FTC in the past has said that it would prefer a kind of a per se rule where these kinds of agreements are presumed not to be legitimate unless there is a sort of compelling justification that is provided for them. And
Other than the enrichment of the brand drug company.
Right, a compelling public health justification, not a compelling personal or market profit justification. And I do think that might be a good model to consider.
Professor Olson, would you like your thoughts on that as well?
Yes, I agree. I think that there is a case to be made for per se treatment. The Supreme Court did not do that in activists, but I think the court eventually is getting to the right answer, but it will take many, many years, and it's hard to come up with much significant harm that would come from simply prohibiting transfers of value to the generic company for basically delaying.
And I'm wondering whether any of the members of the panel, as my last question, have any suggestions of improvements that we might make to the CREATES Act or consider. I expect that Professor Olson, you were nice enough to describe the CREATES Act as an elegant, narrowly tailored fix. Nobody's ever called our legislation elegant, so we like that. But I'm just curious to know whether or not you think there are ways that we could improve the legislation that you've reviewed.
Yes, sir. So I do think that it's narrowly tailored, and I'll stick by the word elegant. I think there could be some leeway on the period of, is it 30 days or 45 days? I wouldn't go, is it 120 or 150 days? But I wouldn't go much farther, and I would point out that coming up with an ATASU in the first place, the company's only given 120 days, so I think the timeframes you've chosen are very good. And I think there are other ways to address the issues you're getting at that would go beyond the CREATES Act, but for what the CREATES Act is specifically getting at, I think it does a very good job.
Thank you. Doctor?
I guess I would just go back to my point that, I think that if you want to focus on just the issues that the CREATES Act covers, which is the REMS and the products, I mean, I think that you could add provisions that would, again, require REMS information to be public, so there is no proprietary information about REMS, so that everybody knows what's in a REMS, and generic manufacturers can create their own REMS without having to haggle with the manufacturer for proprietary information. And I think you could include provisions that do not allow REMS patents to be listed with the FDA, so that they don't block entry of generic drugs as secondary patents.
Great. Anyone else?
I'll just briefly say it's interesting, this our notion of the REMS as sort of a regulated public utility model, and certainly possible. There are, to the extent, and again, I really don't know enough about science, but to the extent you do have one sort of optimal set of safety protocols, there are some issues. I think in that situation, though, if you wanted access to this, you would not necessarily, the brand name drug company, I'd say, wait a second, okay, can see that argument, but we shouldn't have to bear all the costs and the risk of developing it. There should be some way of having the FDA or getting some compensation and making sure that everyone has sort of access to this efficient public facilities. You have to also take that, the potential cost to the brand companies as well.
I just want to echo that, and I agree. And I think that managing the REMS through the FDA instead of making them be managed through the companies would be helpful, and again, with the proper resources, because, as I said before, it is optimal for patients who don't know who their generic manufacturer is, because generic drugs are interchangeable with each other, to have to go to different REMS based on whoever the generic manufacturer is inefficient, and would be frustrating for me as a clinician to try to figure out, well, who should I be calling? Which registry should I be calling? It should all be centralized, and the best, maybe the optimal way to do that would be to have the REMS authority be within the FDA, and the FDA to be properly resourced to run the single central REMS, and then none of these issues would exist.
Great. I know my time. Thank the chairman for indulging me. Thank you very much. Yield back. Oh, I knew that. No, I'm good.
Would each of you, if you care to respond to my question, give an explanation for the general public, because we're throwing around a lot of language here and testing and retesting. What if an originator of a drug has to go through to get that drug to the market, and what difference is there, if any, for the generic company to get that drug to the market? So please.
I'll start. So, a brand name manufacturer usually has to go through a period of preclinical testing that leads ultimately to an investigational new drug application, and then a period of clinical trials that takes on average about 6 to 7 years, and then files a new drug application with the FDA that then is reviewed in on average about 8 months. Brand name manufacturers, or generic manufacturers have to prove that their drug is bioequivalent, which is to say, based on preclinical and very limited clinical trials, show that the bioavailability of the drug and the blood levels of the drug for their version is the same as the brand name version, which is why, of course, the samples of the brand name version are so critical. And then go through again, a more limited FDA review process, only because there's less data that the generic manufacturer is submitting to the FDA. And then the generic manufacturer's drug may be evaluated by the FDA as being interchangeable and be able to go on the market.
Can you give an estimate of some time, because you did bring out estimate for the original company of 78 years of just one segment of testing.
Right. I think that the bioequivalence testing can take far less than that. It probably takes in the sort of months to small number of years, rather than on average about 6 to 7 years. And the generic review period by the FDA, as of 5 years ago, was actually much longer than the brand name review period because of far less resources that are dedicated to the Office of Generic Drugs. That's changed in the last few years, and now the generic drug review process is faster, although still I think averages more like 12 to 18 months rather than on average about 8 months for brand name drugs.
Anyone else?
No, I think actually Dr. Kesselheim's description of the approval, the two different approval pathways is entirely right. The only thing I would add is that I believe the Federal Trade Commission wrote a few years ago that the process for developing and getting a generic drug approved was 3 to 5 years. I don't know if that remains true, but that's what they said in, I think, 2009.
So I just want, Professor Olson?
Yes, I just wanted to, I agree with that process. I want to add on, though, it's a little bit different for large molecule biologics. So for large molecule biologics, the testing for a generic takes longer, and it's much more complex because it's a more complex molecule and because the cell lines can change some over time. So it's key that these generics are provided samples not just once, but several times over a period of, could be a year or so. And that actually makes the CREATES Act, or some approach like it, very important, because a brand name could basically disrupt and ruin the testing of someone trying to do a biosimilar simply by not providing samples in the middle of a testing procedure.
Congressman, could I just make one comment on that? FDA has actually said that a biosimilar company can use a foreign sourced version of the reference product for much, probably not all, but much of that application. I just wanted to make sure you were aware of that.
Obviously, there's no other. Congressman Cicilline has something.
Yeah, Mr. Chairman, I was just asking unanimous consent to make a part of the record this article, Drug Wars, A New Generation of Generic Pharmaceutical Delay by Robin Feldman and Evan Frandorf, as a part of the record.
Without objection. This concludes today's hearing. I want to thank you very much. We could sit here for another 24 hours, and I got a million questions in my head, but as always, if you have anything to offer us, Mr. Cicilline, as what we usually say, either one of us, is, what do you think of our legislation? That's important to us. You're the experts, we're the legislators, and we need your assistance as well. So again, thank each and every one of you for being here. I'm sure we'll see each other in the future at some time. So without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing is adjourned, and we're going to go vote again shortly.